Hey everyone, I'm Brian T. Bradley. I'm an asset protection attorney. You may have heard me or not talk on or and lecture on a bunch of wealth and investment shows on how to protect your wealth and your assets. But I want to spend a few minutes talking about why we even care about this. Why asset protection? Why is it so important in this modern times? Like, what's going on? What's changed? What are we actually fighting? And we're living in a fascinating time right now. We're seeing laws and policies drastically change every day, and people getting sued and being sued that normally wouldn't be getting sued. So protecting your assets, your wealth, and your legacy is even more important now than ever. We have over 40 million lawsuits filed in the US each year. Plaintiff attorneys are constantly advertising for new targets, meaning you. The claims by former employees, along with employment law claims, harassment, discrimination, and wage and hour claims, are just skyrocketing. And I'm actually used to do a lot of these types of claims back in the day when I was starting out in law and doing a lot of trial work. So I'm very intimate about that type of game as well. And the U.S. legal fees exceed over 300 billion annually, and insurance companies are constantly denying claims now. They want your premiums, but they don't want to pay you when you need them, especially for the big things. So I want to start with just the very basics. What is asset protection, and what are we really trying to accomplish? Asset protection is simply creating a legal barrier between your assets and a creditor, the person suing you. At its base core level, it really is anything that would protect an asset from a creditor. It really is that simple. It's like a safe that you want to put your valuables, like your guns and jewelries, watches and gold, tucked away safely into that safe. How we go about it is what's important. For example, if a client is broke, meaning they have nothing, you own nothing, that's one form of asset protection. You have nothing for anybody to get. And I'm a big believer in the Tony Robbins principle that success leaves clues. And if you want to be rich, mimic the rich. And just like the rich, we want our clients to benefit and get the benefit out of their assets, the use and enjoyment out of what you own, while separating out the liability side of it. Rich people don't own things in their personal names. They just use them, they enjoy them, and they benefit from them. What we want our clients to do is be able to go out and use your boat or your plane or your car, enjoy it, rent out those properties, build your portfolio, but you just don't want to own them in your personal names. Instead, your asset protection trust and your business entities own it. The role of asset protection is simple. It's peace of mind. It's lifestyle preservation. When a client calls and is asking for asset protection, that's really what they're saying. I want to sleep well at night. And this really is the problem that we're solving for the clients when you call. You want less stress knowing your finances and assets are safe. Asset protection planning is our modern best bet to level the playing field against this out of control legal system. And we do this by using all the different legal tools that we have. It's just not a one size catch all, which you might hear from other people talking about. There's a lot of different ways to skin a cat. And so we have to look at different tools that we can use that fits the client's profile. And our two biggest ones are either exemption planning and asset protection planning using LLCs, limited partnerships, and asset protection trust. What exemption planning refers to is the type of protection we get from states and federal laws that exempt assets from creditors. The creditor is valid, the claim is valid, the judgment against you is valid, but it's just that this asset is just not something that you can collect on. A few examples of this are homestead exemptions, like in Florida, or ERISA plan retirement exemptions, which are federally protected. IRA plans, which are state protected, so that you get some variation from state to state with that. Same with life insurance and annuities, and some assets through bankruptcy. The way most exemptions are accessed is through bankruptcy, so it has some limitations, and exemption planning can be very powerful though. Now, asset protection planning is different. It does not rely on state or federal statutes to say, hey, these are exempt. It just uses legal tools to limit the access of an asset to a creditor. And these are, spendthrift trust, charging order protection entities like LLCs and limited partnerships, or locked up unreachable assets, because while the asset's locked up, there's no access to cash, and that's what the creditor is after. But what we're talking about as asset protection attorneys are asset protection trust and charging order protection. You may be asking, okay, so which one is better, exemption planning or asset protection planning then? And you may be looking at exemption status and thinking that that looks better, so why not just do 100% exemption planning? But the drawback with exemption planning is that it can't just be arbitrarily expanded. You can't just say, okay, great, exemption planning, your state has all these exemptions, let's just move all your assets into them. And it's really hard to convert 100% of a client's assets. So then you need additional planning. So best practice and procedure on this would be to first maximize exemption planning and then move on to asset protection planning and combine domestic and offshore planning. And so what this does when it's done right is that it makes it very hard for creditors to collect on you. And what we, the attorneys, are concerned about is collectability. Now you might be asking me, Brian, okay, but what's up with the legal system? What's changed? Like, what's so bad about it to have to go to this extent? Well, a heck of a lot of things have changed over the past 40 years. It's no longer about justice, but redistributing your wealth. Now, for people who grew up with the more old school mindset where lawsuits never were really an issue, back about 40 years ago, you could essentially have everything in your own personal name, or in a family revocable living trust. That was acceptable then, and you can get away with that about 30 or more years ago. But over the past 40 years, the litigation landscape has just completely changed. Things that just didn't happen in the past, or that weren't even allowed to happen in the past, like contingency fee lawyers or law firm advertising, are commonplace. And this created plaintiffs with no skin in the game and nothing to lose. And the US does not have a if you lose, you pay system like other countries. And so we have plaintiffs simply looking for a target to get a big payday out of, and a legal system that's not looking out for our clients. And then clients also have their own false sense of security. And I see that what is contributing to this false security and mindset comes from people thinking that they just don't need to do anything and just ride lady luck. They don't appreciate the risk until honestly it's too late. And once you're sued, it's too late to do anything. Or you think that your insurance, and an umbrella policy will always cover you, which it won't. It's important to have, and you need it, and you need good insurance. But we're getting more and more clients with claims that are just radically in excess of their insurance coverage. So being underinsured is a big problem. And you need to remember, insurance just provides capital to fight. Once that capital is eaten up through the courts and litigation and trial, you're still on the hook and your assets are for the judgment. Or the insurance provider does what insurance companies do. They create legal wiggle room through claims of intentional acts and wrongdoings. And then when you are being sued, they're going to tell you that, they're not going to cover you. And if you think that they're wrong, go ahead and sue them. And so now you're left with a two-way lawsuit, being sued while you also have to go and sue your insurance provider. And then we get into the world of high net worth and affluent families and wealth, kind of the world that we work in. At this level, we have to deal with the microeconomic global issues. The big picture really is that we have a global financial system that has structurally deep-rooted issues, along with government-backed fiat currencies that are now in question. And this also includes the US dollar. The US dollar is no longer exempt from this. And then the monetary policy today is very plain and simple: inflate or die. With governments looking for deep and accessible pools of financing, meaning your money and your assets. And then we have financial repression, monetary, economic manipulation. That is just adding more and more challenges to protect and preserve your wealth. This is where a full and diversified asset protection plan really comes into play. This is where we go beyond just an LLC. My recommendation would be to, go ahead and email me for a consultation, and we will do a full risk assessment and asset evaluation. Then we can determine what tools you need to give you that confidence and comfort that you're looking for. My email is Brian, BRIAN, at btblegal.com. And my email is www.btblegal.com. And I hope that you have a better understanding about just what we are up against and what you're facing as investors and building your wealth and building your businesses. The rest of the videos that you can see and watch will be about the tools and breaking down the different tools that we use. And I hope that this short video here was helpful in just understanding the mindset and the lay of the land and the landscaping of the world that we're living in now. Have a great day and thank you. Bye.